All right, we're now joined in studio by attorney Ian Levitt, who was representing the Frankel 8. Thank you for being with us. How are you feeling?
Ecstatic. It's a major day for me and for my clients, and I really believe for many people out there who've been afraid to come forward, who've been blocked from coming forward, and they now can.
And are they ecstatic, the women?
Absolutely. Frankel allegedly abused both boys and girls, so now men and women, and they would have liked to have seen Frankel in the accused box, would like to have looked into his face, but they're ecstatic. There's no words. This is what you go to law school for.
Yeah. And did you know it was coming, or was it, touch and go? You weren't sure?
Well, the Frankel's team opposed this application. Then they withdrew certain opposition to the application. Right until he died, they opposed him being prosecuted. The minister opposed it initially, and then flip-flopped quite a bit, and so, but I think before the court we were confident during argument that there would be a victory. To this extent, we're beyond happy.
So the Frankel 8 formed around this man, Sidney Frankel, alleged to have abused them. And they came together, and he died in the middle, and the case carried on. Just give us a little bit about the history, why they decided to push, and how it became much bigger than just him.
Well, initially, a couple of the plaintiffs came to see me about 3 years ago. They don't all know each other by any stretch of the imagination.
Do they now?
Well, they do now.
Yeah.
And one was abused when he was in an orphanage, and the other was the daughter of the secretary of Frankel for 30 years. So they come from very disparate backgrounds, and when the ball started rolling, it was in Nose Week that people started hearing about this. That they realized, if other people were going to go push for their rights, they wanted to do so as well. Must remember that I've seen many more than just the 8. I've seen very many more than just the 8, and they aren't ready to put their name down to paper yet.
Okay, but they may be in future. This means technically you can go to court if 40 years has gone by, if 30, 40, 50 years has gone by. Why is that important? What difference does it make? How many people are out there who maybe have delayed for various reasons, but they still want to come forward?
The literature shows that the amount of people that come forward that press towards a criminal and a civil case is minute compared to the ones that are actually out there. Why it's so big is not so much that it's 30 or 40 years down the line that somebody can bring a case. If somebody hasn't got a good case, even if it's 1 year, 3 years down the line, the National Prosecuting Authority won't prosecute. So what it means is that the National Prosecuting Authority once again gets its inherent powers to decide what's a good case and what's a bad case. And if it's a good case, and it's over 20 years, then they will be prosecuted.
People are sometimes unsympathetic to women or men who wait that long, and we know that there's memory loss, and so somebody's put on trial for something that happened decades ago, that they say, how can this person remember? Miranda Friedman said something. She was saying when you're young, say, the sacrifice to go to court is huge, and you may decide to do that later. Are these the sorts of discussions we should be having?
Absolutely. Well, one must, if one's unsympathetic towards a 6-year-old who's been abused, who hasn't got the wherewithal to go to the police station and lay charges against her father's best friend, those people that aren't sympathetic, I've got no sympathy for them.
But sometimes even adults wait for various reasons.
Absolutely. So we all know a minute amount of what really goes on behind closed doors, why victims of sexual abuse and spousal abuse do not go and lay charges against their own husbands, whether it's for the sake of their children, whether it's for the sake of their parents, whether it's for there's a magnitude of reasons why people in the form of sexual abuse do not immediately run off to the local police station and have their loved one, supposed loved one, arrested and put in jail. It just doesn't happen. If one delves deeper into the psychology of abuse, we must remember that it's often the parent. It's often the parent's best friend. It's betrayal. It takes a long time to confront betrayal.
All right, finally, so this doesn't go into our law straight away. There's a bit of a process, so it's suspended for now. Just tell us what happens from now.
Well, what happens now is that any decision by High Court on the constitutional issue of any matter must be confirmed by the Constitutional Court. The papers are in the process of being drawn up and should be submitted to the Constitutional Court as early as the end of this week. And are you expecting a fight there? No, we are confident that the Judge Claire Hartford was correct in her decision. We have a fantastic team of counsel. We had Anton Katz who argued this. We have a brilliant team, and we're on the right side of the law, I believe. All right, so what happens now is the Constitutional Court must rubber stamp or confirm this order in order for it to be effective. What happens then is Parliament will then have 18 months within which to amend the laws. However, the judge in this case stated that pending the amendment of the laws by Parliament, people can still bring their cases, even if it's beyond 20 years, and if it's a good case, they must be prosecuted. All right, thank you so much for your time this evening. Ian Levitt talking about the lifting of the 20-year expiry date on those prosecutions of sexual offences.